Court, please. Appeal in the matter of AE Iraq and the Secretary of State for the Home Department.
Yes, Mr. Mackenzie.
May it please the Court, I represent the appellant, and my learned friend, Ms. Patry, represents the Secretary of State. As the Court will have seen, this is a case which revolves around the appellant's conviction for offences under the Terrorism Act, essentially relating to the use of social media. And the Secretary of State consequently sought to deport her. She applied for asylum. The Secretary of State accepted that she couldn't be safely returned to Iraq, her home country, but decided she was excluded from the Refugee Convention. And the Secretary of State advanced two cases, only one of which, of course, we're concerned with today. First of all, she argued that that the appellant was excluded from the Refugee Convention under Article 1FC of the Convention, because there are serious reasons for considering that she's been guilty of acts contrary to the purposes and principles of the United Nations. We'll come back to the detail of that shortly. And secondly, that she had lost protection against expulsion or refoulement under Article 33.2 of the Convention on the basis that she'd been convicted of a particularly serious crime and also constituted a danger to the community of the UK. On her appeal, of course, the First Tier Tribunal decided both those points in her favour. The Secretary of State appealed to the Upper Tribunal. The Upper Tribunal set aside the decision of the FTT on the Article 1FC point only and remade it and dismissed the appellant's appeal under Article 1FC, but upholding the Tribunal's decision, the First Tier Tribunal's decision under Article 33.2, at least on the point of danger to the community. And of course, there's been no cross-appeal by the Secretary of State, so the First Tier's decision that she's not a danger to the community stands, and we're obviously not concerned with that in this appeal, although we may need to briefly look at how that was dealt with, just for context. Now, as the Court is obviously aware, paragraph 4 of my skeleton now, as the Court is obviously aware, Article 1A of the Refugee Convention
just give us a moment, please, Mr. Mackenzie. Thank you.
So Article 1A of the Refugee Convention, in essence, provides that a refugee is a person who has a well-founded fear of being persecuted for one of the reasons set out in the Convention in their country of origin. Article 1F excludes certain categories of persons from the benefits of that status. So the provisions of this Convention shall not apply to any person with respect to whom there are serious reasons for considering that. There are three reasons, of which the third, the operative one, is that he has been guilty of acts contrary to the purposes and principles of the UN. And the leading judgments on what that means are the judgments of this Court and the Supreme Court in the case of Al-Siri. Now, as I said at paragraph 5, it's uncontroversial that the burden of proof is on the Secretary of State. That's Lord Justice Sedley in Al-Siri in this Court. I'm not proposing to take you to that. It's in tab 2 if you need it, but as I say, it's not controversial. Most of the legal framework we can take from the judgment of Lady Hale and Lord Dyson in Al-Siri in the Supreme Court, which I would like to look at if I may, and that's tab 1 of the authorities bundle. So just looking at page 769 of the report, which is page 26 if anybody's using the electronic bundle. 769 of the report. Paragraph 3, we have the text of Article 1F setting out the three limbs of it. So first of all, relating to war crimes, crimes against humanity, B, serious non-political crimes, and C, acts contrary to the purposes and principles of the UN. In paragraph 4, the EU Qualification Directive is said to reflect and slightly expand on that definition. and then particularly over the page at 5, we see that the transposition of the exclusion categories from the Refugee Convention into the Qualification Directive involves making clear at subparagraph C in the indented text that the purposes and principles of the UN are those set out in the preamble and Articles 1 and 2 of the UN Charter. Then paragraph 7 of the judgment, there's a reference to domestic criminal law. Well, I'll come back to that if I may, because that's a sort of discrete issue. And then at 9, a reminder of what the preamble and Articles 1 and 2 of the Charter actually say. And perhaps I could just ask the court, rather than reading it out, to look at 9, 10, and 11 there, please. And then at 12, under the heading, the general approach to Article 1FC, we have submissions by the appellants and UNHCR, which are approved in summary at 16. And at 16, we have, this is the correct approach, the Article 1FC should be interpreted restrictively and applied with caution. There should be a high threshold defined in terms of the gravity of the act in question, the manner in which the act is organised, its international impact and long-term objectives, and the implications for international peace and security. And there should be serious reasons for considering that the person concerned bore individual responsibility for acts of that character. However, those general observations aren't enough to determine the individual cases. And the quoted passage there, defined in terms of the gravity, etc., is from the United Nations High Commission for Refugees background note on the exclusion clauses, which is quoted in more detail at 14. And the whole thing, again, we don't need to go to that, but in case you need it, the whole thing is in the authorities bundle at tab 13. The court then proceeds to look at the facts of al-Siri. In short, he was accused of involvement in an assassination in Afghanistan. And it discusses the interrelation between domestic criminal law and the Refugee Convention, which, as I say, I'll return to in a moment. But then if we could just turn up page 780 of the report, please. Paragraph 37. So the court notes that the UN Security Council has declared that acts, methods and practices of terrorism are contrary to the purposes and principles of the UN. This is repeated in recital 22 of the Qualification Directive, but it's done so in a context where there is as yet no internationally agreed definition of terrorism, no comprehensive international convention, and where the international declarations adopted by the General Assembly are headed measures to eliminate international terrorism. Above all, however, the principal purposes of the UN are to maintain international peace and security, to remove threats to that peace, and to develop friendly relations among nations. And then at 38, in those circumstances, it's our view that the appropriately cautious and restrictive approach is to adopt paragraph 17 of the UNHCR guidelines. Article 1FC is only triggered in extreme circumstances by activity which attacks the very basis of the international community's coexistence. Such activity must have an international dimension. Crimes capable of affecting international peace, security, and peaceful relations between states, as well as serious and sustained violations of human rights, would fall under this category. Again, I don't think we need to go to that document, but it's at tab 14 if it's needed. And then at 39, we have the essence of terrorism is the commission, organisation, incitement or threat of serious acts of violence against persons or property for purposes of intimidating a population or compelling a government or international organisation to act or not to act in a particular way. Then leaving out a couple of lines, as Lord Justice Sedley said in the Court of Appeal, the use for political ends of fear induced by violence. It seems to us, very likely that inducing the civilian population, terror in the civilian population, or putting such extreme pressures on the government will also have the international repercussions referred to. And then 40, finally, is it enough that to meet that test that a person plots in one country to destabilise conditions in another? This must depend on the circumstances. Then again, leaving out a couple of lines. No, sorry, not leaving out a couple of lines, apologise. It clearly would be enough if the government or those in control of one state offered a safe haven to terrorists to plot and carry out their operations against another state. Then in the last 4 lines of that paragraph, the same may not be true of simply being in one place and doing things which have a result in another. The test, and this is the key sentence in my submission, is whether the acts in question have the requisite serious effect upon international peace, security, and peaceful relations between states. And then finally, for the moment on this judgment, could I ask the court to turn up the penultimate page, which is 790 of the report, please, 790. And this takes us to the standard of proof. And perhaps I could just ask the court to read paragraph 75, please. So what sort of activity, short of actual involvement in violence, does have the requisite serious effect, or is capable of having the requisite serious effect upon international peace and security and peaceful relations between states, as the Supreme Court puts it? Well, one answer to that is given in the case of Yusuf and N2 in this court, which is tab 7 of the authorities. And this is a case in which this court gave guidance on the approach where, as in this case today, the allegation is not that the individual has been directly involved in violence or conspired to cause acts of violence, but they've encouraged or glorified or incited support for such acts by things they've said or written, published. So there were 2 separate appellants. Mr. N2, his facts were somewhat remote from this case. He was found to be a sleeper for a terrorist cell, which was intending to carry out actual acts of violence. But the facts of Yusuf were very much more in the same territory as this appellant, albeit with some differences, of course. If we could just look at paragraph 9, please, just for the context of the points the court later makes. This is the judgment of Lord Justice Irwin. So the case against Yusuf is set out there, essentially, in the indented paragraph. So it's that he knowingly incited and encouraged acts of international terrorism, contrary to the purposes and principles of the UN. Paragraph 10, it's important to note that it's not alleged that he incited or encouraged any specific piece of violence, or that any specific act of terrorism can be shown to be linked to the incitement or encouragement. Rather, he had towards the end of the paragraph, praised Al-Qaeda and its leaders, often by individual name, and encouraged others to follow them and support them. Paragraph 11, the material relied on consisted of speeches, sermons, commentaries, etc., made over the course of 10 years between 2004 and 2014, these for the most part being posted on a website. The court notes that this included material explicitly praising Osama bin Laden and other leading Al-Qaeda and jihadist members. And then over the page at 14, the court says, we've had the opportunity to consider the transcripts of the postings ourselves. The context and presentation, says Mr. O'Connor for the Secretary of State, are of significance. The website presents the appellant as a scholar and a man of intellectual authority with a master's degree and doctorate in Islamic law and associated with an institution called the Makrezi Institute of Historical Studies in London. Website cites a large number of his publications, sermons and talks. And then paragraph 15, a reference to his website, or the website which contained his material, receiving tens of thousands of hits. So his appeal against exclusion, Mr. Yusuf's appeal against exclusion, was initially allowed by the First Tier Tribunal and dismissed by the Upper Tribunal. He appealed to this court on a number of grounds, of which only the third needs to concern us, because that's the one in the context of which Lord Justice Irwin makes the comments I'd like to take you to. So paragraph 81, which is internal page 27 of the judgment, so Yusuf's third ground is broader, not concerned with the technical requirement for crime in international law, but with the seriousness of his conduct in a larger sense. No point can be taken about the international nature of his exhortations and incitement. That requirement is clearly satisfied. The question is whether the tribunal considered sufficiently closely and fully the seriousness and impact of the appellant's conduct and reached proper conclusions on the point. His Lordship then cites Al-Siri at 36 to 40, including the passages we just looked at. And then at the bottom of internal page 28, paragraph 83, perhaps again, rather than reading it out, I could ask the court to read 83 up to 86, please. And just for context, the Security Council resolution, which Lord Justice Irwin refers to at paragraph 84, is set out in its material parts by His Lordship at paragraph 41, which is internal page 17 of the judgment. It's a much longer document, the whole of which we've got at tab 15, but the key parts, I think, are set out by Lord Justice Irwin there, so one can see the Security Council expressing grave concern about foreign terrorist fighters people travelling abroad to participate in terrorist acts, resolving to address this threat at the bottom of the first paragraph. Second paragraph, expressing concern over use by terrorists and their supporters of communications technology, including recruiting and inciting people through the internet. And then third paragraph, calling upon states in conformity with international law, in particular international human rights law and international refugee law, that refugee status isn't abused by the perpetrators, facilitators of terrorist acts, including foreign terrorist fighters. And so on the facts of Yusuf's case, N2 loses his appeal. Yusuf wins to the extent that his case is remitted to the tribunal because the tribunal is found to have erred in failing to give sufficient attention to the gravity or seriousness of his conduct. And you've got the subsequent UT decision at tab 8. I believe Marlene Frome may wish to take you to it. I'm not proposing to, because we say it's a decision on its facts. But it's noticeable that the only point I'd flag up, I think, at this point is that even on the facts recited by the court, which we just looked at, the court didn't consider the matter cut and dry. It evidently did think it could have been open to the tribunal to go either way on the facts. So the key point I submit being made in Yusuf is the need to consider both the quality of the acts in question and their gravity or severity or impact, those words being used by Lord Justice Owen to denote essentially the same thing, against a background, of course, of the Supreme Court having said that there needs to be a high threshold of seriousness if someone is to be excluded from international protection and a serious effect on international peace and security. And in the context of someone who hasn't committed, as I say, or conspired to commit actual acts of violence, but rather is glorifying or encouraging support for international terrorism, it isn't going to be sufficient to focus simply on the contents or the quality of what a person has said or written. There also needs to be some evidence of real-world impact, some evidence that people are listening to the individual in question, maybe even acting in consequence of what they see or hear. And that's what is being referred to when Lord Justice Owen talks about evidence of wide international readership, large-scale repetition or retweeting, citation by those who have moved to join an armed struggle. Obviously, he's not identifying those as necessary prerequisites for exclusion, but in this context, they are the kind of factor that one is looking for in order to show that international protection from human rights abuses isn't being denied to somebody who hasn't actually done anything in the real world which is sufficiently serious to warrant denying that protection. And there is a spectrum of seriousness, those are my words rather than Lord Justice Owen's, a spectrum of seriousness in which the hypothetical teenager in his bedroom, to which Lord Justice Owen refers, may be somewhere near the bottom. And the issue is then where on the spectrum any particular individual, whether it's this appellant or Mr. Yusuf or anybody else, is to be located. And all of that in the context of the fact that the UN Security Council, the resolution which we just looked at, directly calls upon states to take action against people who incite support for terrorism over the internet. Even despite that, there's still a necessary level of seriousness or gravity below which the person doesn't merit being excluded from international protection. And that, of course, is then a matter for the decision maker to evaluate on the individual facts. And then finally on the case law on exclusion, just coming back to the interrelation between domestic criminal law and the Refugee Convention, it's, I think, clear now that the definition of terrorism in international law is, sorry, the definition of terrorism in domestic law is broader than that in the Refugee Convention, broader than the definition adopted in Al-Siri. And the domestic definition appears in Section 1 of the Terrorism Act, which we've got at tab 10 of the Authorities Bundle. Perhaps I could just ask the court to read subsections 1, 2 and 3. So the effect of that is that terrorism includes any use of firearms or explosives for the purposes of advancing a political or ideological or other cause, regardless of whether the action also involves intimidating a population or influencing a government. And that is then purportedly applied to exclusion cases by Section 54 of the Immigration, Asylum and Nationality Act 2006, which we've got at tab 12. And perhaps it's quite short, perhaps I could just ask the court to read through that. So on its face, what those two sections together mean is that anyone involved in armed combat in pursuit of any political or ideological cause, as well as anybody encouraging or inducing other people to do so, is deemed to be acting contrary to the purposes and principles of the UN, and therefore to be excluded from the Refugee Convention. However, I'm at paragraph 18 of my skeleton. However, the courts haven't accepted that. They haven't accepted that definition should apply for purposes of interpreting the Refugee Convention. Obviously, that's an international instrument which uncontroversially has a single, true and autonomous meaning, as it's been put, and it can't be legitimately interpreted differently by different states. And the authority for that is Lord Justice Sedley in Al-Siri in the Court of Appeal. And perhaps I could just ask the court to turn that up. It's tab 2, internal page 9. Perhaps I could just ask the court to read 28 and 29, please.
So that reading down, is that I'm perhaps oversimplifying, but is that reading down of the primary legislation a bit of retained EU law?
Yes, as I understand it. As I understand it, the qualification directive is still retained EU law.
Because there's a reference in one of the other cases to some domestic implementing regulations which implement the qualification directive.
Yes, there are qualification regulations, but in any event, the directive would be
But I mean, the regulations may well be retained. I mean, if the regulations have been retained, then they've been retained, I suppose.
Yes.
But I suppose the problem there might be that Section 54 is primary legislation and regulations are regulations. So,
well, as Lord Justice Sedley says there, obviously the directive dictates the meaning of the primary legislation. But I mean, I don't understand anybody to be arguing that the qualification directive is not.
Well, perhaps I shouldn't have asked the question.
No, not at all, my lady. I mean, it did occur to me, but I mean, my learned friend, I'm sure, will correct me if I'm wrong.
Yeah, but I mean, it's
I'm
not
confident it is.
Essentially, the lawfulness or otherwise of that reading down in the present situation is not an issue on this appeal.
No, absolutely not.
All right.
Maybe something we'll have to come back to in the future, but yes.
All right.
Maybe that's what I wanted to say on Article 1FC. I've set out in my skeleton a short section on Article 33.2 at paragraph 20 onwards. As I've said, obviously that's not a live point in this case any longer. That's just for context, and I won't take you through that. The only point I'd just flag up is that Article 33.2 requires a person to be currently a danger to the community, and it's on that basis that the appellant, primarily on that basis, that the appellant wins at both tiers of the tribunal on the basis that she's not found to be a current danger to the community, whereas Article 1FC is entirely backward-looking. There's no possibility of expiation, there's no possibility of rehabilitation. Once you've committed those acts, it doesn't matter whether you're still a risk. And then finally on the case law, perhaps I could just draw attention to a couple of, I hope, fairly uncontroversial points about the role of the upper tribunal in supervising the first tier tribunal. Could we look first of all at UT Sri Lanka, which is tab 6. This is an Article 8 appeal relating to a father joining his wife and children in the UK. But the passage I wanted to look at is paragraph 19 and 20, please. And again, could I just ask the court to read those, please? And then tab 5, please, which is the more recent case of Laing, a deportation case. And could I just ask the court to look at 28 through to 31? Obviously, the reason I'm advancing, the reason I've drawn attention to those passages is not because my learned friend was advancing the same kind of argument which was rejected on part of the Secretary of State in those cases, but because we say essentially the tribunal lost sight of those principles.
Yeah.
And we'll come back to those obviously in a second. Perhaps I could just then turn to the facts, and I'm at paragraph 25 of my skeleton. And I'd just like to look at the background to this case briefly and how the case against her was being put before looking at what the First Tier Tribunal made of it. So she's an Iraqi national. She arrived in this country at the age of 15 in 2007, joining her father who was already here. And she was aged 25 by the date of the hearing before the tribunal, First Tier Tribunal. And the case against her was set out in the Secretary of State's refusal letter, which we have in the court bundle, beginning at page 170. And perhaps I could just particularly draw attention to paragraph 8 at page 171. So the Secretary of State correctly sets out that the appellant was convicted of offences, firstly under Section 1 of the Terrorism Act 2006 of publishing or causing another to publish a statement intending to encourage terrorism, and secondly distributing or circulating a terrorist publication. And this, as I say, related to her use of social media. She was disseminating material online which encouraged young Muslims to go and support or join jihadi groups fighting overseas, and she got 42 months, as we see at paragraph 9. And it extended between, as we see from the dates in paragraph 8, extended between June 2013 and May 2014, so just under a year. And as I say, there was and never has been any suggestion that she had joined any such groups or that she had carried out or planned any kind of act of violence. This was solely to do with her encouragement or incitement of others to do so on social media. And then paragraph 29 at page 175. So paragraph 29, the Secretary of State says, it's considered that as you've been convicted of a particularly serious crime related to terrorism, for which you were sentenced to 42 months imprisonment, you meet the threshold of Article 1FC. Sentencing judge commented, this material and its dissemination is an important factor in the encouragement of young men and women to travel abroad and engage in acts of terrorism, a matter of great and justified public concern. You are disseminating such material on a massive scale over a period of just short of a year. An indication of how busy you were in this activity is that on a site associated with Al-Qaeda, we'll come back to that, but on a site associated with Al-Qaeda, your Twitter account was noted to be one of 66 important jihadist accounts. The material you were disseminating encouraged young men to go and fight, and you now accept that was your intention. That's a reference to the fact that she had initially pleaded guilty on the basis of recklessness, and that wasn't accepted. So she changed her basis of plea. She accepted she had intended the outcomes. And furthermore, to encourage women to go and support them, and indeed to bring up their children in the belief that it's their duty to take up arms, to wage violent jihad and embrace martyrdom. Furthermore, to encourage mothers to be proud of their sons who die as martyrs. The material included gruesome images of corpses and prisoners about to be beheaded. You intended to encourage this, as you now accept. Secretary of State then goes on to say, your conviction and actions described above are considered to be contrary to the purposes and principles of the UN. You are encouraging people on a massive scale to engage in international terrorism. As such, there's a clear international dimension to your conduct, international peace and security. Your conviction means that the threshold of serious reasons for considering that you've engaged in such conduct has been met. On this basis, you're excluded under Article 1FC. So the reasoning is quite concise, and there's no reference there to any evidence other than what was said in the sentencing remarks. As I said at paragraph 27, it's accepted by the Secretary of State that the appellant can't be removed to Iraq because she would face a risk of being ill-treated contrary to Article 3, partly because she had been publicly associated with Islamic State in that way, and she was granted and remains on restricted leave under the Secretary of State's policy, which relates, of course, to those excluded from refugee status. So the Secretary of State then refuses her protection claim on the basis, as I say, that both Article 1F and Article 33 apply to her. She appeals to the First Tier Tribunal. And we have the judgment beginning at page 80 of the court bundle. So this followed a hearing which extended over 3 days. Evidence was heard not from the appellant but from an expert, Professor Silk, on radicalisation and others supporting the appellant. All of that related to the Article 33 point, essentially, to danger to the community. So much of the judgment is given over to that. But essentially, we say this is very detailed and careful. We can see, beginning at page 81, the court going through the uncontroversial personal and procedural history. Then page 82, paragraph 9, referring to the Secretary of State's case under Article 33(2). Paragraph 10, the Secretary of State's case under Article 1FC. And a reference at line 5 of paragraph 10 to the Secretary of State relying on the remarks of the sentencing judge. Then page 83, paragraph 13, noting the 2 offences, noting that she had eventually pleaded guilty. Paragraph 14, as I just said, the appellant initially only accepted recklessness, subsequently accepted intention. Paragraph 16 on page 84, they say it's important in this case to set out at some length the remarks of the sentencing judge. This is in part because the respondent places such great emphasis upon them in respect to the case against the appellant under Article 1FC, and in part because we haven't been provided with the underlying evidence that was presumably before judge and jury. In fact, there was no jury because she did plead guilty in the end. And this is a point, of course, the First Tier Tribunal refers to again and again in its judgment, the lack of evidence, lack of primary evidence, certainly, as to what the appellant had actually done, and in particular, the lack of evidence as to what impact her actions had had on the wider world. The tribunal then sets out at paragraph 17 the sentencing remarks in some detail, including the passages summarised in the refusal letter, which we looked at, and then further passages relevant to her mindset, again, obviously all of that being relevant not to the nature of her past offences, but to the ongoing danger. So I'll pass over those if I may. Paragraph 87, page 87, page 87 up to page 89 goes through the legal framework, including the passages we've already looked at. Page 90, paragraph 28, they summarise the factual position, and in particular, just ask you to note what's said at paragraph 34 in terms of the claimed number of followers on the appellant's Twitter account. My own friend helpfully confirmed that the number was 8,500, a different figure having been given elsewhere. And then paragraph 42, where a pre-sentence report is quoted as saying, line 4, that the appellant was a prolific poster on Twitter and Instagram, posting up to 50 or 60 times a day, mostly in support of Islamic State. So we can see the tribunal having to sort of piece together the factual case from other documents which have been put in front of it.
So there was more than just the sentencing remarks, because the
There was
PSR obviously would have been a document that the sentencing judge
sorry, I
The,
didn't.
the PSR would have been a document that the judge relied on. So
Yes.
some of the underlying material was there.
Well, the pre-sentencing report itself was referring to the primary material. The concern raised by the First Tier Tribunal is that they don't see any of the tweets, they don't see any evidence of who's following her and so on. So they're getting that evidence from, as it were, secondary material, which is the pre-sentence report. And I think they make a point somewhere, which we'll perhaps come on to, that they're not entirely clear who has seen what material. I think we'll come on to that in a second. The tribunal then goes through the written and oral evidence. As I said, most of that relates to her ongoing risk of reoffending. So we can, as I say, pass over that. And then we get to page 96, the submissions, and then just to look briefly at how the case has been put. Paragraph 71, Malone and Friend relying on a skeleton and respondent's position statement, no dispute as to the offences, nor any issues to the appellant's removal, addressed on Article 33.2, and then submissions on Article 1FC start at page 98, paragraph 83, stressing with respect correctly that Article 1FC is a historical assessment only, danger to the community relevant, burden on the Secretary of State, reliance placed on Section 54, which we looked at, domestic definition said to be consistent with the approach of the UN, Parliament struck the correct balance, reliance on al-Siri and Yusuf, which we looked at. End of paragraph 84, no need, again, uncontroversially, to show a direct link between what the appellant had done and any actual acts committed by other people in response. 85, in summary, the combination of the domestic definition set out in section 54, the content and context of the UN resolution and the facts of this particular case went to show the necessary gravity and impact made out. And then my submissions on Article 1F, beginning at page 99, paragraph 88. Again, emphasising, as I did, the absence of specific evidence as to who'd been reading the tweets, whether anybody had cited her posts, whether there had been any real-world consequences, no specific evidence about the website on which her Twitter account had been named, unclear what was meant by a website associated with Al-Qaeda, no evidential context to the Twitter account being on a list of 66 important jihadist accounts. The respondent, we said, could have been able, but had not used such evidence. 89, simply posting on social media not enough. 8,500 followers not a high number. And then 94 and 95, referring again to section 54, referring again to Yusuf, line 4, paragraph 85, which is the teenager in the bedroom paragraph. No evidence from the respondent to show that the appellant had simply sent out numerous tweets, almost all of which were regurgitating what others had created. Paragraph 95, not enough to show necessary gravity and impact in terms of real-world consequences. So those are the battle lines, as it were. Ourselves putting weight on the lack of primary evidence, importance of distinguishing criminal liability domestic law from exclusion, and the Secretary to say necessarily, in the absence of the primary evidence, relying heavily on the fact of the conviction and what's said in the sentencing remarks and to some extent, as my lord said, the pre-sentence report. And the tribunal's own findings begin at paragraph 96, page 100. They go through her life experiences. Over the page at paragraph 102, they make findings as to her life history before coming to the UK. Paragraph 104, referring to concerns about her mental health. And 105, finding that she's been diagnosed in the past with PTSD and depression. Then paragraph 110, on page 102, referring again to the convictions and sentence, and 111, again, in the absence of any of the actual evidence, which was presumably either before His Honour Judge Wyde or had in any event been gathered by the prosecution, Ms. Patry has placed very significant emphasis on the sentencing remarks. She has urged us in the strongest terms not to go behind those remarks. Ms. Mackenzie acknowledges that the judge's comments are, insofar as they go, an important proviso there perhaps, insofar as they go, accurate and should remain undisturbed. Confining ourselves for present purposes to the assessment of factual matters only, we make it clear we're not impermissibly opening a back door to the findings. Insofar as they go, they represent reliable factual statements. Then over the page, paragraph 115, again referring to what's said in the sentencing remarks about encouraging young men to go and fight, encouraging women to go and support them, encouraging mothers to be proud of their sons, and the references to images of corpses and prisoners, etc. 116, although not specifically stated by the judge, it's likely that some of the material would have been avowedly pro-Islamic state in nature. Our view is supported by comments made in the pre-sentence report, although we don't, of course, have the source material, and it's not clear whether the author of the report had in fact seen this. That was the reference I made in answer to my Lord's question just now. And then 117, what's clear to us is that some of the material posted by the appellant was particularly vile in nature, specifically that related to actual or threatened acts of violence against civilians or prisoners. At the same time, we're once again bound to say we haven't, of course, been provided with the actual content disseminated by the appellant. Again, referring to the lack of primary evidence. 118, based on the nature of the counts against her and the sentencing remarks, we find that the appellant didn't herself commit or intend to commit any acts of terrorism. That's uncontroversial. Final line, didn't include the provision of any practical assistance to others. 119, the vast majority of the material posted by the appellant on her Twitter account was not created by her, but consisted of retweeting content originally posted by others. The reference to some responses apparently written or produced by the appellant herself, but we have absolutely no information as to what these might have been, and we're not prepared to speculate what they might have consisted of. 120 hasn't been suggested by the Secretary of State, and there's no evidence which would support any such suggestion that anybody in fact undertook any specific terrorist act as a result of reading material posted by the appellant. We find that's the case. 121, referring again to the scale of dissemination, she posted what we consider to be an average of at most 20 tweets a day over the course of 347 days between June 2013 and May 2014. Again, we note that we don't have the actual figures contained in any material, and they say how they've worked that out. Line 7, the sentencing judge regarded the volume as being massive. In our view, descriptions such as this are always going to be highly subjective. It's perhaps rather difficult to make a finding of fact. The fact that something's massive may well be that the sentencing judge had in mind not simply the total number of posts, but the particular time frame during which these were made. In any event, it's clear that a very large number of posts were made by the appellant over the course of almost a year. We note that our calculation set out in the preceding paragraph is based on what are effectively agreed figures, and then they express concern. The pre-sentence report seems to have been based on an inflated figure for the number of tweets she put out. Paragraph 123, we find as the fact that the number of followers on the Twitter account was 8,500 and not 85,000, as had been stated in the pre-sentence report. And again, that was accepted by both sides. 124, they then expressed some concern that the figures before the sentencing judge may not have been accurate. But at 125, they say again they're not going behind what is stated on the face of the sentencing remarks. Then, having at 126 noted that it's possible to obtain data from Twitter about the number of people who've interacted with a particular account or with a particular individual tweet, at 127, the tribunal again says that there's no evidence before us from the respondent as to how many of the 8.5 followers in fact read the posts put out by the appellant. We have no evidence as to the extent of any retweeting by followers of the appellant. And they note, again, this kind of evidence could have been available over the page. 128, they say they've got no evidence as to who was following her on Twitter. and the final sentence of 128, it's a simple statement of fact, but we've got no information as to the nature, profile, or potential social media following of anyone among the 8,500. 129, on the basis of what is said by His Honour Judge Wide, we find the appellant's Twitter account did in fact appear on a website associated with Al-Qaeda, and that it was in a list of what were described as 66 important jihadist accounts. What we're unable to do is make any further findings of fact relating to the nature of the association between the website in question and Al-Qaeda, the particular content of the website itself, whether, for example, the list containing the appellant's account only ran from 1 to 66, or whether the list had been selected on the basis of content or the number of followers or perceived influence as opposed to sheer volume. Our inability is based on the absence of evidence from the respondent. 130 then goes on to discuss the appellant's state of mind and her credibility, makes reference to the unimpressive impression she made on the judge, all of which again goes to current risk rather than past acts. Then moving on to 139 at page 106, the tribunal raises the question of the appellant's views at the time of the offences, and at 140 they say, taking the evidence before us as a whole, we find that it's more likely than not that the appellant did hold what can properly be described as extremist views at the time of the offending period. They give reasons for that finding, but then over the page at 142, they say that her views were not in fact entrenched, and again they give reasons for that, and they find that she doesn't hold extremist views on the basis of the evidence, doesn't currently hold, that is, extremist views on the basis of the evidence they've heard. And then at 108 onwards, they look in considerable detail over about 40 paragraphs at her current state of mind, or her state of mind since conviction, and her current circumstances. Again, those aren't relevant, but the only point I'd flag up is paragraph 184 at 114, where the tribunal says, we've endeavoured to reach clear findings of fact in respect of what we consider to be the relevant issues in this appeal. Our findings have been based on the evidence before us taken as a whole. We emphasise that reference to the evidence. It may sound trite, but we're a tribunal of fact and law that bases its decisions on the material placed before it by the parties. It's a matter for each of them as to what evidence it deduces or chooses not to deduce in any given case. The absence of specific evidence relating to the appellant's social media activity has been something of a recurring theme throughout our findings. And they then continue their assessment of the evidence up to paragraph 200, 117. They conclude that her offences were not particularly serious. That wasn't upheld by the upper tribunal. But then at 203, they conclude that she, in any event, doesn't constitute a danger to society. And they give 7 reasons for that conclusion. Again, we don't need to look at those in detail, but they extend over a further 10 paragraphs or so up to 214. So they accept she's not a current danger to the and at 215 on page 119 they direct themselves to Article 1FC. So they go through, summarise the law. There's no dispute, as I understand it, this is a correct, indeed impeccable summary of the law, referring to 1, high threshold, 2, burden of proof on the Secretary of State, 3, serious reasons for considering is higher than reasonable grounds, more than mere suspicion, but less than beyond a reasonable doubt. 4, acts contrary to the purpose and principle of the UN has an autonomous meaning. Domestic legislation is relevant but not determinative. 5, issue of nature or quality of relevant acts should be separate from their gravity, impact or severity, obviously a reference to Lord Justice Owen. 6, in assessing the gravity of acts, it's not necessary for the respondent to show any particular terrorist act was carried out as a consequence of the appellant's actions. And 7, fact-specific assessment. And applying that distinction between quality and gravity, or quality and impact, It was accepted by the appellant throughout that her tweets were of a quality that brought her within the scope of Article 1FC. What was disputed was their gravity or impact. And the tribunal notes at page 121, paragraph 220, that the respondent has failed to show that the appellant's act was sufficiently grave in terms of their impact upon international peace, security, and peaceful relations between states. This conclusion is based on the following matters, all of which should be read in conjunction with one another. And they give quite a lot of reasons, not all of which are then quoted by the tribunal, I should point out. So 221 and 222, they say that the appellant's state of mind and her intention to do what she did was relevant but not determinative. They say that's a point in the Secretary of State's favour. That's the end of 222. 223, another point in the Secretary of State's favour is that she held extremist views at the relevant time. 224 and 225, they then deal with the relevance of the domestic law definition of terrorism, and they say, line 3 of 224, that the Section 54 definition relates more to the quality of acts than to their gravity. In other words, it helps to define what constitutes terrorism rather than defining the seriousness of the acts in question, against obviously the need for an impact on international peace and security. And then the end of 225, they say they have taken Section 54 into account, but they don't accept the submission that the correct answer in this case should simply be on the basis of the domestic expression. Next page, 226 to 228, much the same goes for Security Council Resolution 2178, which is the one cited by Lord Justice Irwin, which we looked at his summary of, which essentially they find not helpful as to the issue before them of gravity, but which they say they've taken into account. Then 230, they don't place significant weight on the sheer volume of the appellant's Twitter activities because they find her circumstances, line 4, were sufficiently analogous to the immature teenager described by Lord Justice Irwin in Yusuf. We conclude, as Lord Justice Irwin appears to have, that volume doesn't necessarily equate to acts being sufficiently grave. Having said that, the volume is to be seen in combination with all other relevant factors. We do place weight on it, although that weight isn't particularly significant. 230, again, they don't find the number of her Twitter followers to be of great significance, and that's in part because it goes on to note at paragraph 232, once again, that it's got no evidence as to who may have been viewing her posts, line 2, or retweeting them. No evidence, line 3, that anybody of any influence was commending the appellant. Line 4, no evidence of any comments posted to her account indicating admiration or confirmation of her actions having had an impact on people's behaviour. And then over the page, no evidence that anyone following the appellant on Twitter had actually committed terrorist acts or been motivated to go and join an armed group. And at the end of 232, they accept that the absence of such evidence is relevant to our assessment of gravity. Of course, they're not saying that those are necessary prerequisites, but they are saying the fact that those factors not present is relevant, and that we would suggest is correct, indeed impeccable. They then go on to contrast that position, the appellant's position at 233, with the facts in Yusuf, where the tribunal, it says, was presented with a good deal of relevant primary evidence. 234, it notes the paucity of evidence on one of the key planks of the Secretary of State's case, namely that the appellant's Twitter account is said to have been mentioned on a website associated with Al-Qaeda as one of 66 important jihadist accounts. And we already looked at what they said at 129, and just to reiterate, that was the tribunal commenting they had no evidence of the association between the website and Al-Qaeda or as to the content of the website, or indeed what it even meant to say the appellant's Twitter account is on a list of 66 important accounts. Nevertheless, they do take this into account on the Secretary of State's favour, at the end of 234, but again, not a strong point in the Secretary of State's favour. 235, 4 lines from the end. Again, we find the tribunal lamenting the lack of evidence on the key issue of whether any follower of the appellant had in fact travelled abroad to engage in acts of terrorism. And then 236, noting a distinction between the appellant and Yusuf, specifically that the appellant hadn't put herself, like Mr. Yusuf did, forward as a scholar or person of influence. 237, they return to the actual content of the appellant's posts to the extent that they've been described by the sentencing judge, noting again, line 3, that they haven't made privy to the background evidence. And again, at the end of paragraph 237, drawing a parallel with the comments of Lord Justice Erwin and Yusuf, saying, last 2 lines, the existence of nasty content and potential risk in relation to followers would be inherent in the example provided of the immature teenager. The point obviously being that if it was sufficient to simply look at the contents of a person's online activities, then the hypothetical teenager who's putting out lurid exhortations to jihad would have been excluded on Lord Justice Erwin's hypothesis, whereas the whole point of the conjecture is that he's not. 238, the tribunal asks itself whether there are any additional factors to meet the high threshold for exclusion or aren't. They do say that there are factors in the Secretary of State's case, notably at line 5, the inclusion in the list on a website and the volume of posts made during the offending period. But these are not sufficiently strong, alone or in combination, for the respondent to be able to show that the high threshold in relation to gravity and impact has been met. And of course, at the risk of stating the obvious, that's quintessentially a matter for their judgment, taking into account all relevant matters. 239, they say, the fact of her convictions doesn't show that the actions met the requisite threshold, and its conclusion is at 240, that she's not excluded. A conclusion which we respectfully say was not only correct and lawful, but not surprising. Given the requirement for a careful and fact-specific assessment in which a domestic conviction is insufficient, in which there requires to be evidence of an impact on international peace and security, as against the reality of this case in which the evidence was thin. So we've got a first-tier decision in which no one disputes the law is impeccably set out. No one disputes that each piece of factual material is considered. No one says that anything relevant is left out, albeit there are disputes as to what they should have made of some of the material before them, particularly the sentencing remarks. And as far as I'm aware, nobody is suggesting that the steps to that conclusion are anything other than meticulously set out. I'm very far from saying that this was an inevitable conclusion and that every tribunal would necessarily have reached the view that they did. But this is clearly, we say, a careful, detailed decision which is well within the bounds of available conclusions, bearing in mind the material which was, and perhaps more significantly, was not before it. Nevertheless, the Secretary of State, of course, seeks and is granted permission to appeal. And she has 4 grounds of appeal. Only one of those relates to Article 1FC, and we can find that at page 57 of the court bundle. So this is the Secretary of State's ground 1. The heading is at the bottom of 56. Paragraph 3 is just summarising the factual situation, and the objection is at paragraph 4. The tribunal went on to conclude that the acts committed didn't reach a sufficient level of gravity, and in doing so went behind the remarks of the sentencing judge, who had already made findings on the gravity of the conduct. He had concluded that the appellant had retweeted jihadist material on a massive scale. She had been included on a website of important jihadist accounts, and that she had intended her acts. All of these issues go to the gravity of the acts, but the FTT seems to have focused almost exclusively on the consequences of the tweeting, rather than the fact that the acts in and of themselves were of sufficient gravity. This amounts to an error of law. So there seem to be two, albeit related complaints there, both of which appear to boil down to taking into account irrelevant factors or failing to take account of relevant factors. So first of all, tribunal erred in going behind the remarks of the sentencing judge, and secondly, erred in focusing almost exclusively on the consequences of the tweeting rather than the fact, as it's put, that the acts in and of themselves were of sufficient gravity. And the rest of the grounds of appeal don't concern us because they related entirely to Article 32. Now, the Secretary of State's appeal comes before a panel consisting of Judge Perkins and Judge Craig, and it begins at page 35.
Sorry to interrupt. So, Mr. Mackenzie, permission was granted by the upper tribunal, not by the First Tier Tribunal itself.
As I recall, that's
yes,
right,
I've just
yes.
found the refusal by the First Tier Tribunal. So, I think that leads me to
yes, you've got the yes, indeed, 48 is the grant.
page 48 is the grant.
Yes.
Thank you. Yeah. So the First Tier Tribunal refusal is on page 7. Thank you.
Yeah, so page 48 is Judge Chalkley, ground 1, arguable that the panel may have erred in law by going behind the sentencing remarks.
Can I just ask this? What's the legal basis on which the judge's sentencing remarks are considered to be written in stone for the purposes of these proceedings?
Well, my lord, I since my lord puts it like that, I'm not sure that I could entirely answer that. I mean, it is common practice in the tribunal, particularly in the deportation context, to follow the judge's sentencing remarks.
I mean, I know this. We're not talking about strict rules of evidence,
No.
but the strict rules of evidence are not sort of fantasy land. They do have some common sense.
No,
origin.
I think insofar as they set out matters of fact, they were not really disputed.
No, I think in this case it doesn't really matter
Yes.
very much. But since the only ground of appeal on which permission seems to have been given is that the tribunal went behind the I just wondered why that's a ground of appeal to start with.
I mean, my lord, I have to confess I hadn't given that any thought, but I mean, as I say, I suppose the objection is that it's a matter of going behind agreed facts, I suppose, which have been determined in a criminal process.
In a sense, it's unfair to ask you that question.
Well, indeed, it's not. I'm attempting to assist, but I'll certainly yield the floor to my learned friend if she has an explanation. But yes, as I say, certainly in immigration cases, and obviously, as my lord is aware, many immigration cases interact with the criminal justice process to a very large extent. It's commonplace to take the starting point when one is looking at the seriousness of an offence.
I'm sorry, I mean, it's an irrelevant question in this appeal. It just is something that occurred to me because one can envisage a case in which, well, this case almost got there actually because of the evidence that the tribunal considered at first instance about the volume of the tweets, the number of followers.
Yes.
Suppose the judge had made a finding of fact that there were 800,000 tweets because there were 85,000 followers, etc., and it could be seen that evidence was based on a misunderstanding. One might have got into a debate about.
Well, indeed, they do, of course. And we looked at the passage where they say, well, there may have been some exaggeration or some misunderstanding as to the number of tweets, and they do quite correctly reach their own findings of fact, which ended up being undisputed. I don't believe that volumes are actually set out in the sentencing judge's remarks, and this is why we then have a slight controversy over what he means by
There's not
massive.
actually a disagreement with what he held.
Yes.
No,
so
sorry,
they
I didn't want to take you off your course. You were going to show us the decision of the other tribunal.
Not at all. Yeah, so 35 is where it begins. So they go through the facts in the first few paragraphs. Paragraph 7 is an important one, I think certainly from a learned friend's case. They say the claimant, as they're describing the appellant, has committed offences under the Terrorism Act 2000. I think it was 2006 actually. But such offences are emotive, and it's perhaps particularly important that we remind ourselves that we are not, at least initially, primary decision makers. Our function is to see if the Secretary of State is able to show that the First Tier Tribunal's decision to allow the appeal was wrong in law. We must be careful to apply our minds dispassionately and clearly to areas of law that might be thought technical, and given their importance, might be thought surprisingly unclear. That, I think, is uncontroversial as far as it goes, and of course my learned friend relies on it to say, well, they did have the correct test in mind, and obviously I'll come back to say why we respectfully say that's not the case. Paragraph 8 through to 12 summarises the law in, again, I think, uncontroversial terms. Paragraph 13, they say correctly that the First Tier Tribunal explained its reasoning with some care, and go through in the next few paragraphs the main findings. Paragraph 17, they refer to section 54 again, and paragraph 18 to the judgments in Al-Siri and Yusuf. And 19, they say, the First Tier Tribunal, when considering Article 1FC, distinguished between the quality of the bad behaviour complained of, which the First Tier Tribunal was accepted of a kind that could exclude the claimant from protection, and the gravity of the offence which the Tribunal concluded was not of a sufficiently high level to warrant exclusion. So they've correctly set out that distinction, which was important to the Tribunal. Paragraph 20 onwards continues to summarise the First Tier's findings, again in terms which I think are not particularly controversial, up to page 30, sorry, paragraph 30. 31, at page 39, again referring back to the case law, again highlighting the use of judgment over the next few paragraphs. And at paragraph 36, they say the Tribunal's findings and reasons are summarised at 238 and 239 of its decision. I think it's fair to point out perhaps that that's only part of the Tribunal's reasoning on Article 1FC, which in fact, as we saw, extended over about 20 paragraphs or so between 220 and 240, which isn't quoted by the Tribunal, the Upper Tribunal. Paragraph 37 comes on to Article 33.2, and then over the page, paragraph 41 onwards, looks at the Secretary of State's grounds. Paragraph 43 is summarising the ground relating to Article 1FC. Paragraph 44 refers to my learned friend's skeleton, and then it cites again the teenager from the bedroom paragraph from Yusuf. 45, still quoting from the learned friend's skeleton, refers to the subsequent Upper Tribunal decision in Yusuf. 47 and 48 further submissions on behalf of the Secretary of State summarised, including in 47 at line 6, that more weight should have been given to the volume of the tweets, that the decision to give weight to the fact that there was no evidence of retweeting was wrong, and the fact, as it's put, that the appellant's account was on the list of 66 most important Twitter accounts said to be written off for no particular reason as insufficiently strong. 48, still continuing the Secretary of State's submissions, more regard should have been given, this is line 4, more regard should have been given to the sentencing judge having made findings about gravity and severity of the acts, and the core complaint is then said, 3 lines up from the bottom of 48, to be that the tribunal looked for evidence of anyone taking any notice, and the skeleton argument contends that that is not necessary, and more regard should have been given to the sentencing judge's use of the phrase massive scale. then sets out my submissions up to paragraph 54, and page 43, paragraph 55, summarises the position as follows. In line 1, it comes down to this. It's the Secretary of State's contention that the First Tier Tribunal wasn't entitled to find on the evidence before the high threshold had not been reached. The parties agree that the claimant has committed terrorist offences and that she's been involved in tweeting profoundly unpleasant material. There's some disagreement about the extent of its circulation, but on anybody's version it's gone to thousands of people. There's no evidence that anybody has taken any direct notice of it, certainly no evidence that anybody has been actually inspired to do anything of a serious nature as a result of reading it. 56 reminds itself of the UN Charter. 57 reminds itself that there has to be a high threshold defined in terms of the gravity of the act in question. That's the last two lines of 57. 58 notes correctly that all of these things were fully in the mind of the First Tier Tribunal. 59 to 61 again comes back to Lord Justice Irwin in Yusuf, again quoting the teenager in the bedroom paragraph. So up to this point, if one can, as it were, take stock of where the tribunal is, it's now set out fairly uncontroversially the history of the case law, the First Tier Tribunal's findings, and the rival submissions. And then we arrive at its findings, which begin at page 45, paragraph 63. The paragraph number is obscured, but it's the third line of page 45. And it starts off by finding that there were three factors in the First Tier Tribunal's reasoning which we find do at least cumulatively make out the necessary gravity. So this is going straight into the tribunal's own findings on the merits, its own findings on the seriousness or gravity of her activities. It hasn't found an error of law at this point, but it's already setting out its views on the merits, and it's explaining why it's reached them. And it gives three reasons. It says, first of all, the volume of Twitter activity. First Tier Tribunal asserted that on its own is not of great significance. According to the First Tier Tribunal, the problem is not the scale of the dissemination, but the effect it has. We agree in the sense that we doubt that volume alone could establish the necessary gravity. Drivel on a large scale makes a lot of drivel, but wouldn't undermine the purpose of the United Nations. Conduct complains of here it was not drivel. It included gruesome images of prisoners about to be beheaded, which conduct the claimant intended to encourage. I don't think they're saying that she intended to encourage beheadings, but we regard the scale as important. The conduct complained of was not a one-off rant said in private and possibly overheard, but was circulated deliberately to as large an audience but could be found for the purpose of encouraging terror. As indicated, there's some dispute over the size of that audience, but it was conduct intended to and it was sent to thousands of people. So these are the tribunal's own reasons, the upper tribunal's own reasons for its view on the significance of the volume of Twitter activity. It doesn't explain why the First Tier Tribunal wasn't entitled to reach the view it did reach on the significance of volume. It doesn't say how the tribunal had erred in law in reaching its contrary conclusions. Indeed, at this point, it doesn't appear to have found that it did err in law before embarking on its own analysis. The second reason it gives for reaching the view it does reach is 65 timescale. According to the sentencing remarks, this went on for nearly a year, again contrary to the view of the First Tier Tribunal. So, simple disagreement, it seems. Contrary to the view of the First Tier Tribunal, we find that this is a significant aggravating factor that increases the gravity of the conduct. It wasn't somebody sounding off, but persistent as well as large-scale misconduct. Then 66 refers to the appellant tweeting up to 50 times a day. It says her levels of activity, last three lines, take the case away from the isolated youth ranting. Again, that's probably Lord Justice Irwin's teenager in his bedroom, and elevate it into a higher category. And the First Tier Tribunal was just wrong to take a contrary view. Again, my learned friend wants you to find that just wrong means wrong in law. But even if that's correct, which we respectfully dispute, that doesn't explain what was wrong in law with the First Tier Tribunal's view. Then 67, the upper tribunal comes back to the criminal conviction. It says that it wasn't saying that a criminal conviction is necessary or determinative, and we accept that concepts or even phrases that appear in national criminal legislation and international treaties shouldn't be assumed to always mean the same in each context. Of course, the case will go slightly beyond that. But nevertheless, they say the fact that she'd received a substantial sentence of imprisonment was a strong indicator that the conduct was contrary to the purposes of the UN, and the FTT, it said in the final line of 67, had rather lost sight of this. Again, with respect, not clear what error is being found on the first tier's part, but in any event, insofar as the upper tribunal itself seems to have overlooked the need for a significant impact on international peace and security, that paragraph is clearly a misdirection in law, we respectfully say.
I've got a bit lost about the third factor.
The third factor is, I think, the first 2 points being linked. I think that's 67.
So the timescale and the levels of activity are 1 point.
Volume is 1 at 64, timescale is 2 at 65, and then I think the criminal prosecution is 3 at 67. But yes, it is correct, they don't specifically say what is number 3, but I think that must be what they're saying.
So come back to volume at 66.
Yes, they do. And then 68, well, whether that's a fourth point or the third point, I'm not sure. 68, they say that it's significant on a site associated with Al-Qaeda. Her account was noted to be one of 66 important jihadist accounts. We would have liked to know more about that, as no doubt with the First Tier Tribunal. But unlike the First Tier Tribunal, again, apparently some simple disagreement, unlike the First Tier Tribunal, we find that this clear, limited description is enough to show this claimant's activities were of sufficient prominence to be commended by Al-Qaeda. Again, with respect, that's simply not correct. Nobody had said that Al-Qaeda itself had commended the appellant. And the First Tier Tribunal, line 6, was with great respect wrong to say that this wasn't a factor singularly or cumulatively to elevate the conduct to be sufficiently grave and severe to disqualify, i.e. exclude, the claimant. And again, even if wrong there means wrong in law, we're not told what error of law has been made. And then the last 2 lines of 68, there's clear evidence that the claimant's intended behaviour mattered to Al-Qaeda. Again, with respect, that's simply not correct as a matter of fact. Even on the Secretary of State's Secretary of State's case taken at its highest, no one was saying that Al-Qaeda itself had commented on her Twitter account. 67, we have reflected, they say, before making these observations. We do find that the Secretary of State hasn't given the tribunal the assistance it wanted, and that the Secretary of State's case is supported, line 5, by little more than a few selected paragraphs in the judge's sentencing remarks. It could easily have been more, but it was, we find, enough. But the First Tier Tribunal, at the risk of repeating myself, would find it wasn't enough. And again, we're not told why it wasn't entitled as a matter of law to make that finding. 70, the tribunal goes on to say, we've applied our minds carefully to the question of whether we're merely disagreeing with the First Tier Tribunal, which isn't relevant, or determining they were wrong to take the view that it did, which is highly pertinent. We have decided it's the latter. 71 referred again to the contents of the material circulated by the appellant, repetition of her conduct, and the fact that the tribunal, again, once again, misunderstanding this, at line 6, says her conduct has been commended by an Al-Qaeda supporting organisation, and then the last 2 lines, the First Tier Tribunal should have given a lot more weight to these things. This is why we find the First Tier Tribunal was wrong and why we overturn it. So the tribunal was wrong because it gave the wrong amount of weight to certain matters.
And classically, weight is a matter for the first instance decision maker.
Weight is a matter for
Yeah.
Absolutely, exactly, Melody.
And the upper tribunal seems to be encapsulating its reasons for disagreeing with the First Tier Tribunal as being matters of weight.
Absolutely, Melody, yes. So the upper tribunal then goes on to consider Article 33.2. They uphold the First Tier Tribunal's decision on danger to the community, although not on the seriousness of the crime. As I say, that's no longer contentious. And then we finish on page 47 by saying we have explained why we disagree with the First Tier Tribunal on Article 1FC. So, coming on to my grounds, at paragraph 58 of my skeleton, obviously I've partially traversed this in my submissions on the Upper Tribunal's judgment as I went through it. I've already referred the court to UT Sri Lanka and to Laing, and the importance, obviously, of the Upper Tribunal identifying a material error of law before it embarks on making its own decision on the facts. So, as I've said at paragraph 58, the highest the tribunal puts the basis on which it set aside the First Tier Tribunal's judgment is that it was wrong. And as we've seen, that appears on numerous occasions. Paragraph 66, just wrong to take the view that her levels of activity were insufficient. Paragraph 68, wrong to say that the supposed commendation by Al-Qaeda was not a factor sufficient to lead to that outcome. Paragraph 70, wrong to take the view that it did. Paragraph 71 should have given it a lot more weight, and this is why we find it was wrong. And then the final paragraph saying it had explained why we disagree. So those are not errors of law. And in particular, this distinction they draw, or seem to be trying to draw at paragraph 70 between disagreeing with the tribunal and deciding it was wrong, is a distinction without a difference, we respectfully say. As I said at paragraph 61, the tribunal doesn't appear to have found irrationality. It certainly doesn't say that the First Tier Tribunal's decision was irrational in the sense of being perverse, nor does it give any reasons for saying that. It doesn't say anything of that sort. My learned friend in her skeleton goes so far as to say that the Upper Tribunal found that no rational tribunal could have reached the view that the First Tier did reach. But with respect, that wasn't the Secretary of State's ground of appeal. Her ground of appeal amounted to a failure to take account of relevant matters. And secondly, the Upper Tribunal doesn't say that no rational tribunal could have reached the First Tier's decision. It doesn't say anything of that sort. Nor, actually, does it uphold the Secretary of State's actual complaint that the First Tier had gone behind the remarks of the sentencing judge, or that it had focused exclusively on the consequences of the tweeting. As I say, those appear to amount to arguments about relevant and irrelevant matters, but neither of those is upheld, it would seem. Certainly not expressly so. And as I say, even if one, just returning to my learned friend's argument that wrong must be taken to mean wrong in law, because that's how they express themselves at paragraph 7, the difficulty is that even if we substitute that phrase, wrong in law, for the word wrong, it still doesn't help to explain the Upper Tribunal's approach. As I say, if one looks at 71, where the Upper Tribunal says the tribunal should have given more weight to matters such as repetition of conduct, it doesn't help to say, well, the Upper Tribunal found the First Tier Tribunal was wrong in law, because as my lady has just observed, that's not an error of law. And nor can my learned friend's analysis with respect explain that final comment at paragraph 78. We have explained why we disagree with the tribunal. And it's not just the wording. As I say, it's the structure of the judgment which is so striking in my respectful submission, and that undermines, we respectfully say, the Secretary of State's defence. The way the tribunal progresses at paragraph 63, from having summarised the law and the history and the submissions, going straight into those three reasons why it's reached its own view on gravity. So we say, as I've said at paragraph 63, the First Tier Tribunal reached a thorough, careful, rational and lawful decision, correctly directed itself to the law, entitled to point out that there was no insufficient evidence. Very unsurprising that it found no evidence of real-world impact. Insofar as it was relevant, it made clear it wasn't going behind the facts set out in the sentencing judge's remark, but it was entitled to bear in mind that, of course, those remarks are made in the context of sentencing her for domestic offences, which is not the same task as the tribunal is carrying out.
And also, a lot of emphasis was put on the word massive, which is, in the absence of actual figures, an evaluative.
Indeed, as the tribunal observed.
Yeah.
And as I say, the sentencing judge has not answered the question of international impact, which is an essential part of the exclusion, and it wasn't his job to do so. So we say there was nothing in the Secretary State's ground of appeal. The tribunal shouldn't have set aside the first tier's decision, and it shouldn't have embarked on remaking the substantive decision. I've got a second ground, of course, which relates to the way in which they approached remaking it. And that begins at paragraph 66. Obviously, one doesn't need to get onto this if you're with me on the first ground. But there are two aspects to it. First of all, the tribunal misunderstood the evidence, and secondly, it misapplied the test in law. Paragraph 67 of my skeleton now. The tribunal's analysis at 71 doesn't include any application of the judgment in use of the facts. The upper tribunal found that the volume and repetition of her conduct was sufficient to justify exclusion without considering impact in the real world. And it's obviously inherent in what Lord Justice Irwin says, that the actual impact of what a person says or writes or publishes is an essential aspect of the test for exclusion. And if that wasn't so, then his hypothetical teenager in the bedroom would have been excluded, even though nobody on the hypothesis was taking any notice of what he was saying. And as I say, the whole point of that conjecture is that that would be wrong, that somebody in that position wouldn't be excluded. Secondly, it's very clear from the cases we've looked at, the test for offences of terrorism in domestic criminal law and the test for exclusion aren't the same, and so we say the tribunal erred in taking the fact of her conviction as a strong indicator of liability for exclusion. It was certainly a strong indicator, or more than a strong indicator, that she had carried out certain acts, but it's not a strong indicator of liability for exclusion when entirely different legal tests are being applied to those acts. And then thirdly, this point about the commendation by Al-Qaeda, the tribunal seems to have understood that the commendation was from Al-Qaeda, but that wasn't the contention. The contention was on a site associated with Al-Qaeda. Her Twitter account was noted to be one of 66 important jihadist accounts. That was just obscure, as the First Tier Tribunal pointed out. We had no copy of the relevant posting on that website. There was no indication of what it had said, no indication of what who was operating that website, no explanation of what associated with Al-Qaeda means, who had assessed it as being associated, no evidence that Al-Qaeda itself or anybody belonging to Al-Qaeda or forming part of Al-Qaeda had commended her Twitter account. And that comment is repeated by the upper tribunal. It's wrong on each occasion that it repeats it. And that was clearly regarded as highly significant. They pick it up at paragraph 71. They mention it on a number of occasions, and it simply misunderstands the evidence against her. So if we're wrong and the First Tier Tribunal did err in law, then the matter would still need to go back to the upper tribunal for a correct.
Can you just remind me what the evidence actually was, where it came from, on this topic of Al-Qaeda?
Well, it's not entirely clear, but it seems that a website...
It's in the evidence that was before the First Tier Tribunal was the sentencing remarks.
Yes.
And pre-sentence.
Sorry, yes, it appears in the sentencing remarks.
Yeah, that's it.
That's it, yes.
So all the First Tier Tribunal had was the pre-sentence report and the sentencing remarks. Is that right?
I believe that's correct. Yes, my own friend will correct me if I'm wrong, but I believe that's right.
Right.
On this topic, obviously, there's a lot of evidence.
Oh, sure. Yeah. Thank you.
Same lady, unless there's anything else I can assist with.
No. Thank you very much, Mr. Mackenzie. Yes, Ms. Patry.
Thank you very much. With your permission, I'm going to, in these unusual times, my instructing solicitor is following along on the live stream. I think it's that camera. With your permission, I'm going to take out my mobile phone at the end of my submissions just to check whether there is anything else that he would wish me to add. I appreciate that that's not something that's usually allowed outside of pandemic times, but I hope that will be.
Yeah,
With your permission, I'll just do that at the end. I won't have my mobile phone
No, of course.
with me at all times. Thank you very much. Well, as ever, I'm grateful to Mr. Mackenzie for his detailed and eloquent submissions, and in particular the fact that he has set out for you comprehensively the relevant provisions which were in play in this appeal, and also the relevant case law. He's also taken you through in detail the First Tier Tribunal's decision and the Upper Tribunal's decision. So with your permission, I'm going to structure my submissions as follows, and you'll understand that I won't need to go into the level of detail that I was otherwise anticipating given the way that Mr. Mackenzie has approached his submission. So firstly, I'm going to touch back upon Article 1FC of the Convention. I'm going to take you back very briefly indeed to the case law, because Mr. Mackenzie has very fairly set out the relevant cases and indeed the relevant propositions. Secondly, I'll take you to the facts and why the Secretary of State says, and has always said, right through from the First Tier Tribunal until now, so why the Secretary of State says the necessary gravity was on any basis made out here, or any rational basis was made out here. And I think, it's always a mistake to say this at the outset of submission, I think there were 7 relevant factors that went to gravity, but I'll come on to those. Thirdly, I'll explain to you why the Secretary of State says the decision of the FTC was irrational. We see they did go behind what was said by the sentencing judge. And then finally, why the Upper Tribunal was entitled to come to the conclusion that it did, and why this court, I appreciate that Mr. Mackenzie says the Upper Tribunal should have been slow to interfere with the First Tier Tribunal's decision, but this court should also be slow to interfere with the decision of the Upper Tribunal. So that's how I will structure my submissions to you today. However, before I start on those 4 aspects of my submissions, there's, I think, 3 things which I need to say. The first is that this is, on any basis, a very narrow issue that's before the court, and one that doesn't involve any general point of principle. The question really is whether the Upper Tribunal were entitled to find, as I say they did, that the only rational conclusion the First Tier Tribunal could have been reached was that the acts complained of were of sufficient gravity to bring this appellant within Article 1FC.
But the initial difficulty you face, I think, Ms. Patrick, is that the Upper Tribunal don't anywhere say that that's what they
Well, in my
decide.
respectful submission, they do, and I mean, we'll have to look back at the words.
All right.
But that's my position.
Okay.
And in particular, you'll recall that in relation to the website with Al-Qaeda commendation, they say that factor in and of itself made out the necessary gravity. And I see that can only have been a conclusion, that the decision to reach a contrary conclusion was not rationally open. Now, so that's my first one. The issue is a very narrow one. The second thing I wanted to say at the outset is that the court will understand, of course, that whether the issue of whether or not those who are convicted of terrorist offences are afforded the protection of the Refugee Convention is a matter of considerable importance to the Secretary of State and is of wider public importance. The court will understand, and this was all set out in Al-Syria, I don't propose to take you back to these paragraphs, but Article 1F was enacted because member states were very concerned to ensure that certain categories of people were excluded from the protection of the Convention. And thirdly, I accept that the categorisation by both Mr. Mackenzie and the Upper Tribunal, the First Tier Tribunal decision was careful and detailed. However, it is primarily the outcome and not the reasoning of the First Tier Tribunal which was challenged here. And a careful consideration may nevertheless be an irrational one. So turning to the 4 aspects of my submissions, the first was about Article 1F and C and the test. Well, you will know by now that the decision under challenge, the Secretary of State's decision, was a decision that the appellant was excluded from the protection of the Convention by reference to Article 1C. It was also a decision, as you've seen, that she couldn't obtain the protection against return or refoulement contained in Article 33, and only the first of those 2 issues is now still at play because the Secretary of State accepts what the First Tier Tribunal and, more importantly, the Upper Tribunal found in respect of Article 3. The court will appreciate, though, and I think it's important to point this out, what we hear, and as I think, as my learned friend did fairly in his submissions, is that there is one of the central differences between those 2 provisions of the Convention, so Article 1FC and 33, is that Article 1 FC is entirely backwards looking. So it's met or not met by the acts which make up, in this case, the conviction, without more. It doesn't actually matter what the position is now. And Article 33 is about present danger to the community, ultimately. Now, we'll see why that's important, of course, because I will be saying in due course that the upper tribunal was in as good a position as the first tier tribunal to make a determination on whether or not Article 1 FC was met. Now, that's not always the case with the upper tribunal, because the first tier tribunal very often hears evidence and...
isn't that slightly putting the cart before the horse? I mean, that might be true if the upper tribunal had found an error of law, but the first stage is they've got to find an error of law.
Oh, absolutely, that's right. But...
also, I'm not sure how this submission helps you.
Well, I'll come on to the cases that my learned friend has relied on, and perhaps I can answer that more fully in just a moment.
All right.
So that's Article 1 FC in 33, and as Article 33 is no longer in play. In terms of the test and the relevant, basically what Article 1 FC means, you've already been taken to the article, and for the purposes of this appeal, the Secretary of State accepts much of what has been said about the interpretation of Article 1C. So we accept the burden is on the Secretary of State to establish that a person falls within its ambit. We note Section 54 of the 2006 Act, but we also accept that the article, so Article 1FC, must have an autonomous meaning. And that's clear from Al-Siri, and my learned friend took you to the relevant provisions. But, it is also important to understand that we say that Article 54, 1A and B, reflect, we say, the UN resolutions, which I'll come on to in a moment.
Sorry, Article 54,
Section 54.
Right.
Yeah, Section 54.
All right.
We accept that Article 1 FC creates a high threshold. But it is relevant, of course, that Article 1 FC applies to all acts, so it's acts contrary to, and that means that you don't have to have a criminal conviction in order to be guilty of acts contrary to the purposes and principles of the UN. So in Al-Siri and in Yusuf N2, neither Yusuf nor Al-Siri had any relevant criminal convictions. So Al-Siri had been convicted in Egypt, I think, in respect to various crimes, but the tribunal quite rightly held, especially in due course held, that those could not be taken into account. So there was no relevant criminal convictions. There were indictments in the US and in the UK, but there was no criminal conviction. So it creates a high threshold, of course it does, but it is relevant in this context that there was a criminal conviction, because that means the presumption of innocence, which it also attracts, has been displaced. The other relevant principle and aid to the interpretation of Article 1FC are UN resolutions. And I'm happy to take you to these, to Yusuf and to Al-Siri again, but it was confirmed in Al-Siri and in Yusuf that the UN resolutions are a legitimate indicator of what the words contrary to the purposes and principles of the UN mean. And if I can just take you to that very briefly indeed, because it's one aspect of the case law that my friend didn't refer to. So if we start with Al-Siri and the Court of Appeal, which is behind tab 2 of the authorities bundle, and we look at paragraph 30, so internally page 10, you'll recall that my learned friend took you to paragraphs 28 and 29 of this judgment. But paragraph 30, the conclusion reached there is that what may, in my judgment, be a legitimate indicator of the meaning and scope of the preamble, the Charter, or relevant security resolutions. I accept Mr. Ike's submission that Resolution 1624, see above, puts it beyond argument that terrorism is contrary to the principles and purposes of the UN. And then if we look at Yusuf and N2, which is behind tab 7, yes, then at paragraph 43 onwards, you'll see that there's a discussion of the relevant UN material, resolutions of the Security Council and UNHCR guidelines. At paragraph 46, I'm not going to read paragraph 46, but that confirms what is said at right at the end of paragraph 46, confirms that even so careful a jurist as Justice Sedley concluded that relevant security resolutions could be a legitimate indicator of the meaning and scope of the preamble. And then at 55 of the same judgment, the page 21 internally, there is no suggestion that the Charter itself and resolutions of the General Assembly represent other than authoritative statements as to the purposes and principles of the United Nations. So those are the principles, and I think those principles are common ground. So that's why I say there's no general point of principle that's at stake at this appeal. However, it is important to understand in context what the resolutions tell us in my respectful submission and how that assisted. Now we can see the resolutions within the body of the relevant cases, and the 2014 resolution is contained in its entirety behind tab 15 of the authorities bundle. Now that is a resolution which it was accepted in Yusuf, was not before the courts in Al-Siri. It was more recent. And if we look at the text of the resolution itself behind tab 15, my learned friend has taken you to various sections of it. It covers a vast number of, obviously a vast number of matters. And in Yusuf, at paragraph 84, the court notes that the resolution is very direct in its call to action, and the relevant parts are preventing terrorists from exploiting technology, communications, and resources to incite support for terrorist acts, and to ensure that refugee status is not abused by the facilitators of terrorist acts, in all cases acting in conformity with international refugee law. Now, the reason that's important, of course, is because the resolution underscores a state's obligation to prevent terrorists from, inter alia, inciting support for terrorist acts, which I see is directly relevant here. So we have the two resolutions, the 2014 resolution, which I've just taken you to, and we have the earlier resolution relating to terrorism more generally. But of course, there are a number of others. for the purposes of this appeal, those were the two relevant resolutions. Now, my learned friend has taken you through USIF in some detail, so I don't propose to do the same. The key test for the purposes of this appeal was set out at paragraph 83, which you've already been taken to. And the test is whether the resulting acts have the requisite serious effect. In short, do the relevant acts have the necessary character and the necessary gravity? Now, my learned friend said he wouldn't take you to the reconsideration in USIF itself. So the Court of Appeal decided that there had been an error of law in the Upper Tribunal's decision, and eventually it made its way back to the Upper Tribunal on reconsideration. Now, I'm not going to insult your intelligence by saying that that decision on reconsideration, which is behind tab 8, is binding in any event, in any way. It's the Upper Tribunal and it turns on its particular facts. But I included it as a sense check, and also because the First Tier Tribunal, when it was grappling with these issues, asked us whether it had yet been determined, to which the answer was no, it had not yet been determined. And you'll recall the facts of USIF. A gentleman who had published sermons and speeches on a website, a gentleman who had praised Al-Qaeda and encouraged others to follow them and do the same, and a website which, it was said, received 12,000 hits a week. And the points of difference, of course, with the present case were: 1, no conviction; 2, I'm going to show you engagement on a lesser scale; and thirdly, no external validation in the way that there was with this case. And I'll come on to that in just a moment. But the tribunal concluded, we can see behind tab 8, paragraph 41 of the decision, that they would consider the gravity and seriousness of the appellant's conduct are such as to have the requisite serious effect as required by Article 1 FC. Now, it's obviously not appropriate to compare the two cases any more than I have done, but as a sense check, it is important to understand that that case was considered to be sufficiently grave, or to meet the test of sufficient gravity. My learned friend, throughout this appeal process, has accepted that the relevant acts had the necessary character or quality. So the first half of the test, it was accepted, was met. The only question in dispute was whether they had the necessary gravity. The Secretary of State's position,
forgive me,
of course, please.
You always, and I noticed the tribunal always refer to gravity.
Mm-hmm.
Is there a difference between gravity and impact?
Well, they use the terms rather interchangeably. I mean, they said gravity, impact, severity. Those were the three terms that they used rather interchangeably. And certainly,
but distinguishing all of those things from character.
Equality or character, exactly right. Right, but to be honest,
well,
I mean,
I understand the difference. I think I understand the difference between the quality of the act, as it were, and some other things like gravity and impact. But it does strike me that there might be a difference between gravity and impact. Because
yes,
impact is about the effect, and gravity isn't necessarily about the effect.
I agree, but then you get into a discussion as to whether gravity is in fact different from nature or quality, because you know, putting out photographs of prisoners about to be beheaded or beheaded corpses, the nature and quality of that might be made out, but the gravity may also be made out. And you're right, but the impact may not be made out unless you can show that someone actually looked at it.
Yes.
So I agree. I mean, these are real semantics, and that's why I'm going to say in a moment I'm going to come on to the factors that were relevant and did make up the relevant gravity.
But if I may say so, forgive me for cutting across you. It sounds to me as though, and I just want to see if this is the point, because it hasn't been said, and that's why I'm asking you the question, that you are in fact saying that gravity can be established without impact. Gravity in the sense of something like quality. without impact. That sounds, frankly, that sounds like what you're saying. And I'm just
it
trying
is,
to understand
but
whether
you've
it
got to
really
be-
is or not, or whether it's just me.
We've got to be careful, because paragraph 83 of Yusuf sets out some examples of what might constitute gravity, right? But they're not. It's not an exhaustive list by any stretch of the imagination. So yes, that is what I'm saying.
Right.
There are. I mean, in this case, impact was there because a website associated with Al Qaeda had named this as an important jihadist account. So there was external validation, right? The impact was there. If a website could never have named her as an important jihadist account, if in fact they hadn't ever noticed her, and no one had ever noticed her, right? So by definition, there was necessary impact. But yes, as in theory, gravity would be sufficient.
But gravity is an inherently ambiguous concept, isn't it? Because
Absolutely.
something might be grave because on its face it looks like a trivial act, but it has a terrible effect. I mean, I'm just not really sure where this discussion gets us.
I think all that's being said in Yusuf is that if you set up a social media account and you have 0 followers and you put out a tweet saying, here's a photograph of a beheaded prisoner, that would have the necessary quality. But unless someone reads it, it isn't sufficiently grave or impactful. And that's the difference between the teenager in the bedroom who's luridly calling for jihad, either out the window or to his mum and dad or to his handful of friends at school. And then there's so nature and quality.
Well, I'm now totally confused because I thought a moment ago you were saying gravity could be established with you agreeing with my Lord Justice Birss in saying that gravity could be established without an impact, and now you seem to be saying the impact is necessary.
I see. Well, I've never really, candidly, it's not something I've ever had to explore because on the facts of this case, we see impact was made out in any event.
All right.
So it's not something I've ever had to. But in theory, could something be sufficiently grave?
Well, if it
impact
doesn't matter for the
maybe a
purposes
matter
of this
for another
case,
day
let's
at a different
not
case.
speculate.
Absolutely right.
All right, but your submission is there is impact here.
Absolutely. And the Secretary of State's position throughout, before the First Tier Tribunal, in the grounds of appeal, which I'll take you to, at the Upper Tribunal and now, has been that on any rational basis, given the fact and the nature of the appellant's conviction and offending, the only rational answer to that question, whether there was sufficient gravity, was that her offending was of sufficient gravity and impact.
And you're going to show us where in your grounds of appeal to the upper tribunal that was said.
I am. So let's turn to the facts and of the convicting, of the conviction and the offending, which means that assessed cumulatively meant that without question we see Article 1 FC threshold was passed. And necessarily, I think, as has already been pointed out, some of these factors will go both to nature and quality and to gravity. But that doesn't mean they can be simply excluded on the basis that they go to one or the other. They're all relevant. I was going to take you to the decision of the Secretary of State, but my friend has already done that. I don't think we need to. But what's really important in respect of the Secretary of State's decision, of course, is that the Secretary of State only ever relied on the sentencing judge's remarks. The Secretary of State didn't say, I've got all this underlying primary material which I'm going to rely on. The Secretary of State didn't do that at all. The Secretary of State is clear from the face of the decision. The Secretary of State reached her decision on the sentencing remarks. And this might be a good time, before I go on to the factors, to address the point made about the weight to be given or to sentencing remarks by a judge. Well, I'm not sure I have a better answer than that of my learned friend. But on the facts of the present case, both the First Tier Tribunal and my learned friend agreed that the remarks were accurate insofar as they went. So there were a series of agreed facts set out in this. Well, there were facts set out in the sentencing judge's remarks, and everyone agreed that they were accurate, and that's how everyone proceeded. It is a matter of custom and practice in the immigration tribunals that the sentencing remarks from criminal trials are considered to be accurate on the basis that the criminal judge was the person who was presiding over the criminal trial, heard and saw the evidence insofar as evidence is given, and read the relevant evidence. And that's as much as I think I can say. But certainly, if everyone agrees that they're agreed facts, then you shouldn't go behind them. And to do so is an error of law.
Well, it rather begs the question of what facts are.
Yes.
Because sentencing consists of a mix of things, part of which is evaluation.
Yes, absolutely.
And I don't think you'll be suggesting that the judge's observations about it's outrageous that you should be on Twitter with these things is a fact.
No.
There's room for confusion. I'm not saying there necessarily was in this case, but there's room for confusion as a matter of principle. If everyone just says, well, whatever the sentencing judge said is a binding factual conclusion.
Yeah, absolutely. There is room for opinion and fact, isn't there? But the central factors, and I hope that the 7 factors I'm about to go through, you'll see, are fact. They're facts. And yes, I mean, in one respect, the judge said at one point, I don't want to paraphrase, but said something like, I find that this is, that encouragement of this nature encourages people, plays an important role in encouraging people to go and fight for us. Well, yeah, I mean, I don't see that's a fact, and neither does the First Tier Tribunal. But others are facts, and frankly, I'll come on to weight in a moment, but frankly, they are agreed facts, and they have to be accepted as being agreed facts. So turning to the relevant factors in this case, which mean that on any rational basis, the only rational answer we say was that her offending was of sufficient gravity, are as follows. So first of all, you have the conviction itself. So without question, the conviction itself means that there were serious reasons for considering, if you remember the Article 1 SC test, there were serious reasons for believing that. So there was a conviction, and it wasn't just a conviction, because that would get you over the presumption of innocence hurdle, but it's the type of conviction. Now, I'm going to ask you to turn back to section 54, if I may, which is behind tab 12. Now, bear in mind, you'll have to take it from me because you don't have the rest of the 2006 Act, but bear in mind that section 54 contains the only definition of what might amount to acts contrary to the purposes and principles of the United Nations for the purposes of Article 1C. So this is the only definition. Nowhere else will you find a relevant section which sets out what might amount to acts contrary to the purposes and principles in relation to Article 1FC. So we've got 2 acts of committing, preparing, or instigating terrorism, and acts of encouraging or inducing others to commit, prepare, or instigate terrorism. Okay, so those are the 2 things that Parliament has decided in construing or applying Article 1F should be taken as including those acts. And that's important because, of course, there have been attempts to include other things. And some of the background documentation indicates that the UN has had concern, for example, when states try and include things like drug trafficking and people smuggling, etc. But that's not, this is it. This is what the Parliament has decided should be the aid to interpretation. Her convictions, my learned friend has already taken you to the relevant convictions. Most sensibly, they're set out in the First Tier Tribunal's decision at paragraph 13. And you'll see that both offences, they both contain an element of intending to encourage terrorism. So publishing and causing, intending to encourage terrorism, and distributing, circulating, intending that an effect of our conduct be a direct or indirect encouragement to the commission, preparation, or instigation of acts. So they're both intending to encourage or instigate. We see falling directly within section 54(1)(b). And it's important to note that, I think, as my friend has fairly pointed out, that the appellant initially only accepted that she'd been reckless. That wasn't accepted by the prosecution, and she eventually acknowledged her intent. So,
well, as the First Tier Tribunal,
yeah, correctly points out, absolutely right.
So they knew that.
They did know that. So the conviction in and of itself is serious, falls within the definition in section 54(1)(b), and I don't see it taken any further than that at this point. And it involves the finding that she intended to encourage. Now that takes us out, immediately outside the scope of Yusuf and al-Siri for the reasons I've explained already. No convictions in those cases. And in my respectful submission, it takes us away from the random teenager in his bedroom, because there is a criminal conviction. So that's the first factor, if I can put it that way. And then we turn on to basically the facts of the offences.
Would the
Of course.
teenager in his bedroom not be guilty of this offence by posting the tweets that
He might be.
hypothesised?
Well, he might be. I mean, yeah.
The offence doesn't depend on the impact of gravity or whatever you call it.
That's right. But in the example set out in Yusuf, paragraph 83 of the teenager, there is no assumption or indication that the teenager has been found guilty of a criminal offence. So
well, why does that matter? I don't understand why the conviction for the criminal offence makes any difference, because it gets you over the burden of proof hurdle, but what more does it do other than that?
The nature of the offence, the nature of the conviction, can assist in relation to the question of gravity, we see, because A, there's an element of intent, and B, there's an element which relates to incitement or encouragement of terrorism. So those two elements are relevant to gravity, we see. And they bring her within the provisions of section 54.
So what do you say about what Justice Sedley had to say in al-Siri about the effect of section 54?
Well, insofar as the Article 1 FC having an autonomous meaning, or?
Well, what in a nutshell, what he was saying was we don't have to pay any attention to section 54 because the qualification directive has got its own definition and we're bound by that.
I agree, and that's why I said I accept at the outset that I accepted that Article 1 FC had to have an autonomous meaning.
Well, this is a completely different point, because at the moment you seem to be saying that our approach to Article 1 FC is dictated by the way Parliament has said that Article 1 FC should be interpreted. And Justice Sedley in al-Siri was saying no, because qualification directive tells us how to interpret it.
I don't think I've made the submission that you are bound by or dictated to by section 54. The point I make is that...
Oh, right. Oh, sorry, I've misunderstood.
No, not at all.
So what are you saying the effect of section 54 is then?
I say that on the facts of this case, of the present case, she fell squarely within section 54. I mean, unless we say we ignore section 54 completely, which I don't think we do. I think what we say is, on the facts of this case, she fell both within the terms of the UN resolutions and section 54, and the elements of the conviction that meant that both section 54 and the relevant resolutions were relevant were intention and encouragement and or incitement. That's all I say. So there's an academic argument to be had about what weight should be given to Section 54
Well,
generally.
it's not an academic argument, because Section 54 is a provision of primary legislation, and normally we would be bound by it. But I mean, the reason I ask you is because of what Justice Sedley said in Al-Siri. I'm trying to understand what your position as a matter of law is about the effect of Section 54.
Well, we don't go behind what was said by Lord Justice Sedley.
Right. Well, let me get a note of that then. Thank you. All right. Sorry,
So,
I interrupted.
Not at all. Absolutely. The second of the factors which are relevant here, the nature and content of the tweets and posts. Now, I don't want to get again into an academic debate as to whether that went to quality, nature and quality. But in my respectful submission, gravity is informed by the nature of the material that you are distributing, in this case described universally as vile content. Not just calling for the jihad, but including of images which were very difficult viewing. Thirdly, she'd used the internet in precisely the way that the UN had deplored in the 2014 resolution. Fourthly, this is really a sort of volume point. Now, I'm going to assume for the purposes of this appeal that you understand how Twitter works, and that I don't need to take you to the appendix in the Monroe-Hopkins judgment, which Eleanor Friend has helpfully put in the authorities bundle. She had a significant number of followers on any basis, 8,500 followers. And that's relevant to real-world impact and gravity, of course, because it's on any basis, there's the potential for really wide readership. Fifthly, linked to that, she retweeted over the course of a year, and we saw my learned friend has already taken you to that, up to 50 tweets a day. Now that's obviously relevant to impact. And so 50 tweets a day to 8,500 followers is the sending out of 45,000 tweets a day.
As a maximum.
As a maximum, circulating from her. Compare that to, I probably shouldn't say this, but compare that to 12,000 hits a week for Mr. Yusuf. We're talking about 45,000 tweets a day in circulation from her.
Well,
over the
different,
course.
aren't they? I mean, I do understand how Twitter works.
Okay, that's helpful.
Because that was my judgment in Monroe and Hopkins. And I know that the mere fact that you tweet something to a follower doesn't mean that they read it.
Yes, but there is.
Whereas a hit is a different thing. So you're not really comparing like with like.
That's true. That's probably why I shouldn't have said it. but on any basis, it is there. It will appear, if that person chooses to look at their timeline, it will appear on that person's timeline.
If they look quickly enough.
If they look quickly enough. And what Twitter can tell you is whether someone has interacted with the tweet. So it can tell you if someone has liked or retweeted. It can't tell you whether it read it.
But was even that information in front of the FTT?
Yes, of course it was. 8,500 followers was the amended correct follower figure that everyone agreed.
But did anyone know how many people liked things?
No, they didn't know that. They
No,
didn't.
That's what my question was ambiguous.
Sorry, but 50 to 60 tweets and posts a day was in the pre-sentence report. So yes, they did. Now I appreciate that there was an issue, paragraph 122 of the First Tier Tribunal's decision, about 48,000 tweets And it may be that this is where the error arose. But on any basis, we say that is the potential for 45,000 tweets a day. Now, I'm afraid on any basis, the categorization by the sentencing judge that this was tweeting on a massive scale is correct. And the FTT agreed at paragraph 121 of their decision that on any basis, this was prolific tweeting. You probably recall that. In any event, it is clear that a very large number of posts were made by the appellant over the course of almost a year. Sixthly,
Forgive me,
sorry.
for a tedious question.
No, please.
Is this number, and maybe we don't know the answer, this 50 a day, is it the average or is it the maximum? Because I don't understand what the expression an average of at most means.
I think the best we had is the pre-sentence report, paragraph 41, said that the appellant sometimes posted between 50 and 60 tweets a day.
Sometimes.
Right.
Yeah, that's in paragraph 121 of the FTT.
Sometimes posted between, yes, I see.
So when you said up to, that's a gloss, but that reflects what
So I think so.
Yeah. So 50 isn't an average at all. It's the opposite of average.
It's the maximum. 60 is the maximum.
60 is the maximum.
Yeah.
I think that's right. But if she posted 60 tweets a day,
But she didn't.
she did sometimes.
Right, but you said if she posted to us 60 tweets a day, which implied that she did it every day, but she didn't.
No. If on a particular day she
Right.
posted 60 tweets, multiply that by 8,500, that's actually more than 45,000 tweets on that particular day.
Right.
So the potential, perhaps I can put it this way, there were occasions when tens of thousands of tweets will have circulated from her account.
It's always difficult, this analysis, because in the context of commercial publishers who sell
Yes.
copies of their hard copy newspapers, there used to be anyway publicly accessible circulation figures and reach.
Absolutely.
Someone can say, well, you've sold 1 million copies, you've got an average of 5 readers. 5 million people have read the paper, or sorry, bought the paper. There's still a problem in identifying how many people will have read an individual article, because everyone knows that lots of people read some, but not all of their newspapers or magazines.
Absolutely right.
Problems are exacerbated with Twitter.
Yeah.
When people receive.
And it's reversed online, because online you click on an article.
Yeah.
So you can tell exactly how many people have read a particular article, because you actually have to click on it to read it fully. But with Twitter, right, it's difficult. And
Unless you have the analytics.
well, you can tell from the analytics how many people have interacted with it, but you can't. Someone may have
It's a reasonable inference that if someone's liked something or retweeted it, they probably know something about it.
Absolutely, but it's
Not
also a
necessarily.
reasonable inference that you may have read it even if you haven't liked it or retweeted it. You may not like it. You may not want to retweet it, but you've still read it if you regularly are looking at your tweets. Anyway, what matters though, for the I don't say that we needed to nobody needed to speculate. The figures, she was tweeting on a very large scale over a significant period to a significant number of followers. That's all I say. That's what we got from the sentencing remarks and from the pre-sentence report. Sixthly, she held extremist views at the time of the conviction. Now, that is a direct finding of the First Tier Tribunal. We see that in express finding, at paragraph 140. We find it more likely than not the appellant did hold what can probably be described as extremist views at the time.
Sorry, my number of your points. Got so
6,
excited about
number
Twitter.
6.
What was point 5?
I don't think I've ever heard anyone say they were excited by my submissions before. 6, it was number 6. She held extremist views at the time.
I've got that, but it comes out as 5 on my list, so I'm wondering what number 5 was.
5 was the
number of
retweeting,
tweets.
the number of tweets. Sixthly, extremist views, that's the express finding. And there was evidence from a risk expert before the First Tier Tribunal, Professor Silk, but he expressly accepted in cross-examination that he had not assessed her whether she held extremist views at the time of the conviction. So this was finding of the tribunal on other, taking into account other factors. Now, again, we say that goes to the gravity of the act. Someone who holds extreme views, who intends to encourage terrorism, those are all relevant to gravity. And then seventhly, this is my last one, and perhaps the most important one. No, in fact, probably without question the most important one when it goes to gravity, and when you're looking at the paragraph 83 test from Yusuf. She was on a website associated with Al-Qaeda as one of 66 important jihadist accounts. Now, I know and I accept what my learned friend has said about the fact that the First Tier Tribunal didn't have much else to go on. Okay? It repeatedly said to me, Ms. Patry, we don't have any details about this website. We don't know exactly how they've been numbered. We don't know how Al-Qaeda is associated with this website, and I was unable to give them an answer. But what I did say, and what is right, is that the sentencing judge, who did have the primary evidence before him, noted as an agreed fact that she was noted on a website associated with Al-Qaeda 66 important jihadist account. Now that factor alone takes us well beyond the teenager with 3 followers in his bedroom. It gives us external validation by a terrorist organization.
Well, it depends on what the association, the nature of the association with Al-Qaeda is, and we just don't know.
I say that on the facts that we do have, that plainly went to external validation and gravity.
It's very difficult. I mean, the term associated with is always a difficult one.
It is, but it was...
at one end of the scale, a close, intimate associate of.
Yeah.
Obviously doesn't mean this is an Al-Qaeda website. It's in some way associated.
Well, if it's either associated or endorsed in any way by Al-Qaeda, that's sufficient in my respectful submission. If it's associated with it in any way...
No, it's not that, is it, on the sensitive remarks. It's endorsed by a website associated with,
Yes.
not endorsed by Al-Qaeda, but endorsed by an associate of some kind.
A website.
Which is why I'm not
course.
saying you're wrong about this. I just can't really make it's not easy to make out what it all adds up to.
I think all I can say is that on the facts set out by the sentencing judge, this was clearly relevant. It was relevant to his sentencing, and it was an agreed fact. Insofar as it went, it was an agreed fact.
Does anything? What I've done is I've just gone back and looked at what the sentencing judge actually said. Mm-hmm. I'm looking at paragraph 17 of the First Tier Tribunal's decision, which is set out there. I don't know if it's set out anywhere else, and forgive me if it is, but it's the second paragraph under 17, and the judge there is using that as an indication of how busy she was. What does that matter?
Yes, in that context, he was saying an indication of how busy you were on that site. Is that on a site you were said to? So I think the point he's making there, I don't want to paraphrase him, is that there was so much tweeting that you'd come to the notice of this website. I think that's right. That is what's being said. But that doesn't detract from the fact that she had attention of a site associated with Al-Qaeda, and that she'd been noted to be one of 66 important jihadist accounts. So those are two, those facts remain, regardless of whether the judge was using them to deal with I mean, bear in mind that this judge wasn't looking at gravity under Article 1SC. He was...
Well, that's part of the but one of Mr. Mackenzie's points, isn't it?
No, he wasn't. But the underlying agreed facts were relevant to the question of gravity, and that's what we said. I'm conscious of the time.
Yeah.
Is that a good time to stop?
Yes, I think so. We're going to finish presumably this afternoon if we start again at 2.
Of course.
Yes. Just wanted to check, just in case I
Of course.
got the wrong end of the stick. All right. Well, thank you very much. We'll rise.
Court rise.
Huh?
I didn't realise that was Warby.
Neither did I.